Hi, my name is Atul Shrestha, and my group members are Suzan Sarma, Krishna Thapa, Burak Dibek, and Salman Qureshi. In this video, I will be presenting the case North vs Marra Development and will also be representing the defendant, which is Marra Development. Marra Development was a public company which was established in 1954, and five families held about 95% of its paid up capital. Marra stockbrokers, who in this case are the appellants, had discussed with the directors to bring capitalization in line with the real value of Marra's capital. Therefore, North had advised Marra to raise its capital and merged with Scottish Australia Holding Limited. In order to do that, North advised Marra to inform its shareholders about its current positions, to reconstruct its capital, and to take over or merge with Scottish Australia Holding. Stockbroking firm, which is North, one of the members being Mason J, sued Marra Developments for the advice services in relationship to a reorganization of the capital of Marra and its takeover of another company, which is Scottish Australia Holdings Limited. After filing the case, it was dismissed by the court because the action was the defense of illegality based on the breach of the provision of Section 70 of the Securities Industry Act 1970. The parties had conspired to engage in an illegal conduct. So the story starts on the 18th of February 1974 when Mr. Jeffrey, who is the chairman of Marra, advised Mr. David North that a company was contemplating making a takeover offer for Marra at $15 shares. The director decided that the offer should not be recommended and shareholders were informed accordingly. Next, an important discussion took place between Mr. Jeffrey and Mr. David North on the same day or possibly on the following day. The only evidence of the discussion consists of a note made by Mr. North, in which Mr. North advised that the directors should be prepared to buy some shares at par value of 50 cents in order to successfully establish the market. Also, Mr. Jeffrey himself asked Mr. North to help out by buying the shares about that level. On 1st of March, before announcing the merger, but after the reconstruction of the capital, North purchased 1100 Marra shares. In 4th of March, the appellants purchased 1500 shares on behalf of North. And from 5th of March to 16th of April, North purchased on behalf of directors as shareholders of Marra. So literally, North is the main buyer of all the shares and the prices vary from $15.50 to $16.50 for $2 shares. Appellant then sued Marra Development for $140,000, having only paid $35,000 for the original claim of $175,000. The appellants pleaded their case in two ways. The first one being that Marra had to pay for the appellants' fees for the work done. The appellants sued on an account for $140,000, which could be paid in installments of $35,000 in 3 months interval and its interest. Marra's first defense was that the action was illegal and unenforceable because it contravenes Section 70 and 71 of the Securities Industry Act 1970 and the common law. Section 70 states that a person shall not create or cause to be created or do anything which is calculated to create a false or misleading appearance of active trading in any securities or any stock market in keen state, or a false misleading appearance with respect to the market for or the price of any securities. The object of this section is to protect the market for securities against activity which will result in an artificial or managed manipulations. Furthermore, for the second defense, it states that there is no consideration because the forbearance to sue for the sum of $175,000 under the original contract was illusory. The appellants being unable to sue on the original contract by reason of its illegality and unenforceability. David North admitted that it was intention for participating in transactions involving the purchase of Marra shares directly and indirectly to raise the current price on the stock exchange and in order to maintain a particular level. The evidence of the discussion was found and it acknowledges the arrangements made by both the parties in order to establish the market of the parties, showing that North agreed to buy in the market initially in their own account until the arrangement complied with Marra's directives. In addition, the third document prepared by North to the stock exchange, the court found it as misleading. The reference in the third document misled the reader about the significance of the price, and the court also found that the North must have realized this with a purpose to influence those who consider Marra's offer to take over Scottish shares. In conclusion, the appellant's performance of the agreement involved in an illegality, and the agreement itself invades this as a possibility. The appellants fail, not because the arguments on which they sue is avoided by Section 70, but because the performance on which they rely involve an illegal conduct. The consequences is that the claims based upon the account stated and the second agreement must also fail. Therefore, the court gave its discussion favoring Marra development. Thank you.